Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you and welcome. So we are delighted to have you here with us in person today. And we will hear argument first in number 24303, United States versus Skaggs. And Ms. Cormier, we'll hear from, no? Mr. Cormier, I'm sorry, we'll hear from you first.
Thank you. May it please the court, my name is Dana R. Cormier, and I thank you for the opportunity to present oral argument on behalf of the appellant Travis Ryan Skaggs. In 2015, the Wise County Circuit Court convicted Mr. Skaggs on 6 separate charges. There were 3 property crimes, 2 conspiracy crimes, and 1 drug distribution or possession with intent to distribute narcotics. On each conviction, the Wise County Circuit Court sentenced Mr. Skaggs to 10 years of incarceration with 7 years and 10 months suspended, leaving an active term of incarceration on each conviction, 2 years and 2 months or 26 months. And then the court ran all 6 sentences concurrently. So for those 6 convictions and those 6 sentences, and not accounting for any good time credit that Mr. Skaggs may have received, and I'll talk more about that in a moment, Mr. Skaggs served a 2-year and 2-month sentence for all 6 convictions. Now, the issue in this case is whether Mr. Skaggs, based on those 6 convictions and the 1 conviction for the distribution charge, whether he served a term of imprisonment of more than 12 months based upon those 6 concurrent sentences for 6 different crimes, only 1 of which would be a qualifying predicate for the statutory enhancement. It's important to note that what this case, the issue in this case is not about the definition of a concurrent sentence. We all know what concurrent sentences are. And Congress knew what a concurrent sentence was when it drafted the definition of a serious drug felony under 21 U.S.C. Section 802. Also, the issue in this case is not about what a sentence imposed is. Of course, we all know that the term a sentence imposed is the sentence ultimately imposed by a court. We also know that as a practical matter of fact, that a term of imprisonment is virtually never the same as a sentence imposed. In the Virginia statutory scheme for good time credit, there are varying levels of applications of good time credit, and a defendant will serve anywhere from 65% or 85% or up to a maximum of the sentence imposed, depending on the underlying crime and the nature of the defendant's behavior while incarcerated. So we know the statutory scheme in Virginia.
What did Mr. Skaggs serve?
We don't know. We only know what his sentence was based on the record today. While we're on that subject, Your Honor.
Counsel, I'm sorry, if I can just ask.
Yes, please.
You to sort of follow up on that. Did you argue, was it ever sort of suggested to the district court that Mr. Skaggs spent less than 12 months in jail?
I believe, I was not trial counsel, but I believe trial counsel argued, not that he didn't spend less than 12 months in jail. The argument was that he spent less than 12 months on this particular
right,
crime.
but there was no dispute that he served more than 12 months. I understand there was a dispute as to sort of to what we should attribute that 12 months, but he served more than 12 months.
I don't recall in the record there ever being any discussion or conflict otherwise, Your Honor.
Okay.
While we're on that subject where we don't actually know the length of the sentence that he served after accounting for good time, we do know what the sentence was, 26 months. We also don't know how that sentence was calculated. In Virginia, the sentencing guidelines are calculated with a primary offense being setting the base level with additional points for other offenses of conviction. And in my experience, if a breaking and entering charge is the base offense, the primary offense level, that base level of the sentencing guidelines is going to be much higher than if a possession with intent to distribute is the base offense level. We don't know how that sentence was at least determined vis-a-vis each of the separate charges. And again, we also know that the Bureau in the federal system, the Bureau of Prisons calculates good time credit based upon, as the Barber case tells us, what the defendant actually serves, not the sentence imposed. The 802 was amended certainly to narrow the scope of predicate offenses that would qualify for the statutory enhancement here. It was intended to focus on those serious drug felonies that and the seriousness being measured by the length of the term of incarceration that the defendant serves. And we cannot categorically say in this case that Mr. Skaggs served a term of incarceration of more than 12 months based upon the 6 concurrent sentences he received in Wise County.
Counsel, I'm sorry. I know you said at the beginning that we all agree on what the definition of a concurrent sentence is, but I guess I'm wondering if that's true, because I thought it was established that when someone is sentenced on multiple counts and the sentences are served concurrently, what that means is that the defendant is serving distinct and separate sentences on each count, even though they are served concurrently. But do you disagree with that?
They are serving separate and distinct sentences on each count. But again, the issue is, what was the term of imprisonment that Mr. Skaggs served for the qualifying predicate distribution charge? And what the Eighth Circuit tells us, in perhaps dicta in the Cavalucci case, I think I'm saying that right, is that when a defendant serves several concurrent sentences simultaneously, he is serving only a portion of each of the sentences. And that's a language directly from that case. If that's the case, if we're allocating for the six different convictions here, it's 26 months divided by 6 comes up to roughly 132 days.
But even if we adopt the fiction that he's serving a portion of each, how do you know? You just did the division thing. How do we know the fiction isn't that in a typical, say your guy was convicted for 6 offenses, why isn't the fiction that each day he's serving 4 hours on each of the 6? Why do you assume that each day he is only serving? What's the authority for that proposition?
The authority that I have is from the Eighth Circuit's dicta saying that it's apportioned that way.
Well, they just say it's a portion. They say he's serving a portion of the sentence, but they don't say. You want to then further extrapolate from that to say that he's going 131 days on one, 131 days on one, but they say a portion. It could be equally plausibly, I suppose, that each day he serves 4 hours on each of the 6.
It could be equally plausible as well.
But at that
equally
point,
plausible that he's simultaneously, right, that each hour counts for every single sentence, right? He's serving a portion. Every day you're in prison, you serve a portion of your sentence, right? You serve 1 day of the sentence. And it could be 1 day on count 1, 1 day on count 2, 1 day on count 3. All of those counts, you're serving 1 day because you're serving concurrent sentences. That's how the Eighth Circuit was talking about a portion.
Certainly. But the issue is not the definition of concurrent sentences. What we can't say here is whether Mr. Skaggs, how much did he serve for that one qualifying predicate?
No, but under the definition I read you, I think the answer to that is 26 months or some number over 12 months, because you've conceded, I think, that nobody is disputing that good time credits or not, that he served less than 12 months.
But why didn't Congress specifically adopt or say anything about concurrent sentences? Concurrent sentences and consecutive sentences are terms of art that we're arguing about today that are very important in the sentencing scheme. A sentence imposed is a term of art that's very important to a defendant and a very important part of the criminal sentencing scheme. And a term.
Can I give you a
imprisonment
hypothetical?
is
So
distinct.
my understanding is that sometimes judges order terms of imprisonment that are of different durations to run concurrently, right? That's possible. Say on count one, I'm sentenced to 6 months. On count two, I'm sentenced to 6 months. On counts 3, 4, and 5, I'm sentenced to 6 months. But then on count 6, I'm sentenced to 4 years. A judge could order those 6 sentences to run concurrently, right?
Yes.
So how long do I serve on count 6 in that hypothetical? Is your view still that that first 6 months doesn't count at all? How do I calculate how long that individual served a term of imprisonment on count 6, in your view?
What he served on that would be 6 months. I mean,
On count 6, the count to which he was sentenced for 4 years?
I'm sorry, I mixed up.
So counts 1 through 5, he's sentenced to 6 months. Count 6, he's sentenced to 4 years. And then the judge orders all 6 counts to run concurrently. In your view, how long is the term of imprisonment on count 6?
On count 6 that's the 4 years?
Yes.
4 years.
How do you square that with your position that while the
If I'm
person,
understanding your
Yeah.
hypothetical, the hypothetical was that you got a sentence of 4 years on the 6th count?
just on count 6, but counts 1 through 5 were 6 months each, and the judge ordered all 6 counts to run concurrently.
Mhm.
So you think 4 years on count 6?
Is that what he got sentenced?
On count 6, yes.
He would have to serve 4 years, wouldn't he?
Yes, but for
Well,
purposes of this
what's the
statute, I'm just trying to understand how the interpretation you're putting forward would apply in situations where the concurrently served sentences were of different durations.
You would serve that portion of the sentence that you were sentenced to. It would just run concurrent.
Can I ask, what do you think, in Judge Hyten's hypothetical, what's the sentence? So he's going to be in jail for 4 years. How much time serve on count 1? I guess you would say it's a 1/6 of 4 years, right? So it would actually go up. So on your reading of the sentence, this statute, someone who was actually sentenced to say 11 months on a qualifying drug count, with a 10-year sentence on another count, that person would now qualify for the
No,
enhanced
I
sentence.
wouldn't say that.
Well, why not? It seems like it follows directly from your reasoning. You would divide by 10 and he'd be serving 5 years on each count.
Well, how could he serve more than what he was sentenced to on one of the counts?
You tell me. So tell me why your rule
here's the
doesn't
here's
apply
the
in this
problem.
context.
Is that we don't know Congress didn't talk about consecutive sentences. We have to guess what they're talking about. We have to make these suppositions. We have to assume these things that we don't know. But Congress didn't use sentence imposed. Congress didn't say anything about consecutive or concurrent sentences. I'm running out of time, because I would like to preserve some for rebuttal. All I can say is that because of the ambiguity, there's a lot of ambiguity I could talk about on rebuttal by use of this specific term, revocations, all kinds of ambiguities that you can identify here. But because of the ambiguity of this term, I think the rule of leniency would compel the court to rule in Mr. Skaggs' favor, because right now we're all just supposing and guessing of what the term of imprisonment that Mr. Skaggs served under this concurrent scheme. And I'll reserve what a little time I have left for rebuttal. Thank you very much.
May it please the court. I'm Jennifer Bockhorst for the United States. If I can start with 2 points. First, Congress is presumed to know the law when it passes statutes, and the law on what is a concurrent sentence and what it means is long and well established. It actually goes to the foundations of what is a crime, with its parts of an act, and mens rea, and a punishment. And so when Congress passes the First Step Act and is silent as to concurrent sentences, it doesn't create an ambiguity. It's because the law is already clear, and it is presumed that we will all already know that each sentence imposed concurrently to another is its own separate and distinct sentence, and it is fully served. And my second point related to that is, with all due respect to my co-counsel, I think he's misquoting the Eighth Circuit's Corona Verduzco case, and the part he leaves out is very, very important. They say concurrent, and they're quoting a 1973 Eighth Circuit case, concurrent sentences are separate and distinct sentences, that the sentences run concurrently means the privilege of serving each day a portion of each sentence. So what they are actually affirming is, as Your Honor pointed out, you're serving simultaneously a day on count 1, count 2, count 3, count 4, until you reach the maximum length of that sentence imposed. That's what concurrent sentences means. Congress knew that's what concurrent sentences means, and that is in fact all this court needs to find, I think, to resolve this entire appeal.
Can I ask you, so I had the same instinct that I felt like I know what concurrent sentence means, but then when I go looking for binding legal authority that confirms my understanding of what concurrent sentencing means, it turns out to be surprisingly hard. What would you say is the best authority for the proposition that concurrent sentences mean what you say concurrent sentences mean?
I would point the court to United States versus Ball, which is the case actually from my court, where multiple sentences were imposed on what was essentially the same crime, both receiving and possessing a single firearm. And the court finds, they say at one point that the term of imprisonment, the sentence imposed does not evaporate simply because of concurrent sentences. That what Judge Williams had tried to do was cure the fact that it was, well, actually what the Court of Appeals had done was say it's a double jeopardy problem to have two sentences imposed on this conduct because it's the same conduct, and cure it by imposing concurrent sentences. And the Supreme Court said, no, that does not cure it because each sentence is its own sentence. And so the fact that they're concurrent does not eliminate the double jeopardy problem. I think that point is reiterated in just the dicta in Oregon versus ICE, which is the whether Apprendi applies to judge-made determinations of whether it should be concurrent or consecutive sentences. And they point out that by definition, a concurrent sentence are imposed on multiple offenses different in character or at different times. And I think it's also embedded in all of the circuits case law, including the Fourth Circuit. And I cannot, I'm sorry, I do not remember the name of the case in my head, but many times we said under the context of 924E and also under 841B enhancements, if there are multiple offenses, they, in different counts for multiple offenses, they count as separate offenses unless they're part and parcel of the same conduct. So they actually delve into, if you have two convictions in federal court for distribution offenses, was it the conspiracy and the distribution arising from the same distribution, then they don't count as separate offenses. Or if they are occur on 2 different days, then they clearly would. And so I agree with Your Honor, it's not real easy to just find a clear, concise definition, but I think it's embedded in all of that case law. And all of that case law is, the conclusions are premised on this idea that they are in fact separate sentences. And if Your Honors have no other questions, I mean, there were other issues in the brief, but we think that that is the most important or the simplest way for the court to reach the conclusion to affirm this appeal.
So I take it then that you think we don't have to resolve in this case whether the statutory definition, which refers to the offender serving a term of imprisonment of more than 12 months, whether we have to, I take it you don't think we have to figure out in this case whether that means the sentence imposed or the sentence actually served when you take account of things like good time credit, because one way or another, we're over 12 months here.
Yes. While it would be very nice to have that resolved in alliance with the way the Eighth Circuit ruled, I think it is a complicated question, and it is not squarely presented by these facts because there is no contest as to the other elements or how much time was actually served. I'm happy to discuss that issue if the court wishes me to, however.
Okay. No more questions. Thank you very
Thank
much.
you.
And Mr. Cormier, I think you do have time on rebuttal.
Thank you, Your Honor. We have spent a lot of time today talking about sentences, consecutive sentences, sentences imposed. We presume that the sentence imposed on Mr. Skaggs is a term of imprisonment that the Congress meant when they drafted this statute. But they are distinct terms. Congress didn't refer to the sentence imposed. Congress didn't say anything about the initial sentence. It was important for Congress when they said term of imprisonment, not consent, not sentence. It didn't refer to, I can't argue with to the extent that the concurrent, our implicit understanding of concurrent sentences is what it is. But that's not the language that Congress used. They didn't say sentence imposed. They didn't say anything about the sentence. They said the term of imprisonment. That has to mean something. If the Congress does not use what, as counsel has said, is a firmly embedded understanding of what concurrent sentences are and what sentences imposed are. Three distinct terms of art here. Congress only used one. Served a term of imprisonment. For purposes of an enhancement, Congress has directed us to look back and say, what was this term of imprisonment that this defendant served for the predicate drug crime? And I'm not sure that we can categorically say that based on the term, the 6 consecutive concurrent sentences that he received, we can say that categorically he served more than 12 months. Now, it is counterintuitive, I agree, to say that a term of imprisonment.
What I realize that if the text says otherwise, the text says what it says, but I'm just, you're trying to hypothesize what Congress was trying to do. So in your view, if he had just been convicted of count 6 and only been sentenced for count 6, there is no doubt that he would qualify. But your view is that because he was convicted of counts 1 through 5, that means that count 6 doesn't qualify. Why would Congress possibly do that?
Congress used the word that served a term of imprisonment, not sentence. That's all I'm saying. We are jumping the gun.
I know, but do you agree with me that if your client had only been convicted of the drug offense and been sentenced or served 26 months or whatever is more than 12, that he unquestionably would qualify under the statute?
Unquestionably, that was all he was.
Okay, so why in the world would Congress have possibly done the thing that you suggest that they did here?
Use term of imprisonment.
No, not why they use the term they use. Why would they have possibly contemplated the result that a person is better off when he adds 5 more criminal convictions than when he just had the 6th? Why would we treat that why would Congress possibly want to treat that person better?
Because we don't know. The issue is this: Congress is concerned with the seriousness of the drug felony. It doesn't say drug felony, it says serious drug felony. And if we can specifically identify a drug felony where the defendant served more than 12 months, that is a sufficiently serious drug felony for purposes of enhancing this sentence under this statutory scheme. If a defendant served, if we're going to use hypotheticals, if a defendant had 5 drug distribution sentences and got 10 months on each of them, and they were ran consecutively, he would serve 50 months in prison, not accounting for good time, based on but none of those convictions would count as serious drug felonies. Is that what Congress intended? A drug dealer that has 5 different convictions to not have a serious drug felony and to not be enhanced? When someone like Mr. Skaggs has one bundled with some pretty serious property crimes and gets a generic suspended sentence covering all of them, he's going to get the enhancement. I don't think that's the result that Congress intended when it talked about a serious drug felony. And we can't say that in this case that Mr. Skaggs' drug felony was sufficiently serious when bundled with these other very serious property crimes. And we can't say that he categorically served that sentence was categorically a result of his drug distribution and not really the result of his breaking and entering, his grand larceny, and his petty thefts that were all bundled in there, and the 2 conspiracies, which would not be predicates. So that's why I think it's important that we look at the language that Congress used. Term of imprisonment. Certainly it has these counterintuitive results. What if someone gets that 10-month sentence on one count, they get 5 years with 4 years, 2 months suspended. Then they subsequently have their sentences revoked and they serve another 6 months. So then they do 16 months after a revocation. Would that be considered more than 12-month sentence because he served 16 after revocation, or is the revocation distinct? We don't know. We don't know with this, but we do know that we can't say for sure. We don't have, in this case, the case where the prior conviction was singular or clearly resulting in a term of imprisonment, actually serving a term of more than 12 months. And I thank you very much for the opportunity to argue.
Thank you very much. And thanks to both of you for your help today. And Mr. Cormier, I see that you are court appointed, and we especially thank you. We really count on lawyers like you to take these cases and help us decide them. So thank you very much. We will take a brief recess now and then return for our second case today.
the court for appointing me to represent the appellant, Kendall Weisinger, in this very interesting and important appeal. I did not represent Mr. Weisinger in the court below. That was in Harrisburg. He was convicted of several counts, as the court knows, received several life sentences, and the briefs are fulsome. I'd like to focus on counts 1 and 3 and 4 on the merits, and then sentencing issues. That's all right with the court. Count 1 is a sex trafficking charge under 18 U.S.C. 1591, 1594. The issue, and he was found guilty, the issue there is not whether Mr. Weisinger may have assisted some prostitutes or aided and abetted them in engaging in their profession, engaging in prostitution. He did. There's no question about that. The issue is whether the government proved beyond a reasonable doubt that he did so, that he coerced these women into engaging in commercial sex trafficking within the ambit of the federal statute. He did not. Judge Dillon, the trial judge, while she overruled his Rule 29 motion, she said the evidence was weak. And she pointed out she was troubled by the fact that these women could buy drugs from any number of sources. They weren't required to buy from the defendant. She said the evidence is weak, weaker than she's seen in a case like this, but she thought it was sufficient. That was error. It was insufficient. In this case, they presented no evidence of force or fraud. And I see in the brief, I don't think they're even arguing anymore. There's charges using force and fraud, but I think they're conceding there's no evidence of violence toward these women, no evidence of threats of violence. They are essentially resting their case at this point on coercion, that he coerced the women into commercial sex trafficking. And they seem to be, I think their theory is these were not just prostitutes, they were heroin addicts or fentanyl addicts, and he exploited that by selling them drugs.
Well, from your perspective, then, Mr. Bierce, in considering the issue of coercion, does it matter whether the women were addicted prior to their association with Mr. Weisinger?
Yes, Your Honor. Thank you for the question. I think this case would be a lot closer if they weren't. If he had plucked them out of the population and got them, sort of addicted to drugs, and then they could not live without the drugs unless he supplied them with more drugs, that would be a different case.
Counsel, I don't understand why that is when the statute goes out of its way to define coercion and serious harm in terms of a person of the same background and in the same circumstances as the actual victim. It seems as though the statute goes out of its way to say what you ask is whether what the defendant did would be enough to compel a reasonable person of the same background and in the same circumstances as the victim to perform or continue to perform commercial sexual activity. So that sounds to me like Congress has gone out of its way to say, look, you kind of take your victims as you find them. If this woman's an addict, that's baked in to the definition.
Your Honor, I mean, if we're going to read the statute that broadly, anyone that sells...
Well, I'm really just reading the words that are here. Compel a reasonable person of the same background in the same circumstances. What do you think that means?
I think that means that the defendant, to be guilty, has to coerce them, has to use some sort of, has to overpower their will to get them to do what he wants, to perform an act or under the threat of suffering harm. And here,
this may be a nitpicky point, but I think the statute says a person who, maintains, solicits, patronizes, knowing that coercion will be used to cause the person to engage in a sex act. So that the coercion, you just have to know that coercion is going to be used to cause the person to engage in the act. The coercion, you don't have to be, the reason that they began engaging, the reason that they began in the profession or overcoming their will to force it to happen. The coercion is connected to, I think, a different part of the statute.
Yes, Your Honor. But I think to be found guilty, he has to be guilty. He has to have committed some coercive act. Or otherwise, anyone that sells drugs to a prostitute, I guess is guilty of federal sex trafficking. I mean, they were free to buy.
So what do you make of, let's talk about the evidence, right? So there is evidence that if believed, would show that he posted one of these women on a website
Yes.
so that she could pay for heroin that she had already consumed. He had already given her heroin and then said, okay, to pay for that, I'm going to post you on this website so that you can repay me. And then he collects almost all the money she makes and gives her rations for drugs, and controls her calls. Why is that not sufficient under the statute?
Your Honor, I don't think that's the evidence. I think the evidence is before they ever met this gentleman, these ladies knew how to post on that website. It's called backpage.com. All the prostitutes in Virginia placed it.
I'm not saying he taught them how or that he coerced them to do it. I'm saying she owed him money. And so he said, well, here's how you're going to pay me back. And I'm going to take all your money, and to get the drugs, this is how you're going to pay me. Now, the jury could potentially read the evidence that way.
I think the testimony, though, Judge, was that the women asked him, because they didn't have credit cards, they asked him to post pictures of themselves on Backpage. In fact, one says I directed him to. I asked him to. So that's not coercive. I mean, that's a tool of her trade. She asked him to because Backpage wouldn't take cash. She didn't have a credit card. So they used his credit card. So for all those reasons, I would ask that the court find the evidence not simply weak, as the district court found, but insufficient to find him guilty.
Okay, Mr. Beers, one last question on
Yes,
that,
Your Honor.
if you don't mind. And that is, in order for us to agree with you that the evidence was insufficient, would we have to find that heroin withdrawal symptoms cannot constitute a serious harm within the meaning of the statute?
No, I think the court could find that withdrawal symptoms are a serious harm. I mean, that certainly someone can become very sick. That's clearly true. They could become very sick. They could vomit. They can suffer physical injury from withdrawal. I don't dispute that at all. If that answers the court's question, I'd like to go on to counsel.
Let me just ask you one last
Yes.
question about this. So you didn't object to the jury instructions on this, right? So is that right?
I was not trial counsel.
I'm sorry, I meant your
Yes, the
client.
trial counsel did not object. I do have an issue with the trial instructions, but they were not objected to. That's right. I have covered that in the brief. I'd be glad to answer your questions about that.
Oh, no, I'm sorry, not that instruction. I meant the instruction on coercion and harm. So there was no objection to the way the jury was charged on this. We just have to look at the evidence and
Right.
see whether a jury would have been compelled in the light of this evidence to find that this was a voluntary business partnership.
That's correct. It's a
Okay.
sufficiency argument, and I also take issue with the instructions, but I do agree that the trial counsel did not object to the instructions. On counts 3 and 4, trial counsel did object to the instructions. I'd like to go to that, and I think this is reviewed de novo because he did object. The issue there is under section 841B1C. This is the statutory enhancement under counts 3 and 4. This is a distribution of a narcotic, Schedule 1 or 2, that resulted in serious bodily injury or death. He had, according to the government, a prior conviction or two, and therefore he was subject to lifetime enhancement under that statute. The judge, at the request of the government, gave the jury two choices. You can find him guilty under counts 3 and 4 if you find beyond a reasonable doubt that he actually distributed the substance, or if he possessed the substance and with the distributive intent, that he intended to distribute. Trial counsel, I think, did a good job of asking the court to limit the government to proving an actual distribution. But the judge went with the government, and we have guilty verdicts. I think that was error. I think clearly the intent of Congress is that if someone's going to be enhanced and suffer a lifetime mandatory sentence of life in prison, there has to be an actual distribution by the defendant, not simply a possession with intent to distribute.
What about this? The statute also applies that to someone who manufactures. But you wouldn't say that the person who manufactured had to distribute it. Is that right?
If someone manufactures it?
Yeah, the statute says if someone manufactures the drug and the drug serious bodily injury or death results from the use of that drug, then they're also subject to
Yes.
life imprisonment.
Yes.
But the person who manufactured didn't distribute it. They just made it.
Yes, but in this context, I think there's no manufacturing of it. There has to be an actual distribution by the defendant.
Well, I guess I don't see why that is. If the statute says anyone who manufactures, distributes, dispenses, or possesses with intent to do any of those things, the statute applies to them, and then the enhancement applies if death or serious bodily injury results from the use of that substance. So there are many of those things in the statute where you're not the person who distributed it.
But if you're the manufacturer, that implies you're manufacturing for the stream of commerce, and that's not what we have here. But by their argument,
Possession with intent to distribute, you're intending to distribute it in commerce.
So under their construct of the statute, if I'm the drug dealer and I intend to distribute some drugs, but there was a break-in at my house, and someone steals those drugs and distributes them to someone else or ingests them and someone dies, I'm liable under the statute criminally. And I don't think that's Congress's intent. They haven't cited any case law to support that. The case law we have, the leading cases from 2014, the Burrage case by the Supreme Court, and clearly they talk repeatedly through the Supreme Court does about the need for distribution, to show distribution as an essential element of the offense.
That was a distribution offense in Burrage, right?
Yes, it was. Yes, it was. So for those reasons, we'd ask the court to vacate his convictions on counts 3 and 4. But if they're not vacated, I'd like to talk briefly about the sentencing issues with respect to Section 841B1C. And I think the briefs really have narrowed us down to, the briefs, both of us go on and on and on in the briefs, but in the end, I think it's quite simple where we are. He was enhanced because the government filed a Section 851 information or notice saying, you have 2 qualifying predicates. They filed that prior to trial. You have a Maryland conviction for drugs distribution. You have a Virginia conviction. So that's what his notice said. And at sentencing, he was enhanced based on those convictions. Now, I have challenged both convictions. And as a result of the briefing, we now know the government confesses plain error with respect to the Maryland conviction. The government and I agree that we're applying here the modified categorical approach. Yes, Your Honor.
I'm sorry, I found this very complex, and I agree that you and the government have helpfully narrowed your areas of disagreement, but one of the things that I am confused about is the standard of review here. Because as you say, the government filed an 851 notice identifying 2 predicate offenses.
Yes, Your Honor.
Right? And I believe that you and the government both think that one way or another, although I think you think this for slightly different reasons, there was an objection to the Virginia predicate.
Absolutely.
But there was not an objection in this context to the Maryland predicate.
Not a direct objection, although I'm confused because in their standard of review section, they say it should be reviewed de novo if you look at their standard of review in their brief. But the focus of the objections was to the Virginia objection.
Right. And so it seems to me that if you have a notice that identifies 2 predicates for an enhancement that only requires 1, and you only object to 1, you haven't in fact objected to the enhancement.
Well, Judge, I don't know why that would be, Your Honor, because...
Well, let me tell you, because
Okay.
the district court judge would hear, there's a question about the status of the Virginia conviction. Good thing I don't have to resolve it because I've got the Maryland one and no one's objecting to that. So we're fine because you only need 1. So that's why I think maybe you haven't put the district court on notice that you are objecting to application of the enhancement if you've only objected to 1 of 2 possible predicates for an enhancement that only requires 1.
Well, okay, he clearly objected to being enhanced. I think he got the point across. He was objecting. He did it through the career offender guideline.
But that's different, as you concede in your
Yes.
brief. It's a different
Yes.
enhancement.
Yeah.
They have different rules. Your whole argument is predicated on the idea that for one of them, you need a categorical match to the federal definitions, and for the other, you don't. So
Okay.
those are very,
Yes, Your Honor.
those are different legal contexts.
But we have, even if we're on plain error,
Okay.
we have a concession by the government, to its credit, that they lose on the Maryland conviction. They continue, they want to argue about the Virginia conviction, and I see my time is up. Should I
Yeah.
continue?
All right with you guys if we go a little longer? Yeah.
All right, very briefly, they have two arguments. They say, well, the Virginia conviction stands, and even if it doesn't, it has to be remanded, and I would agree it needs to be remanded, but give us an unrestricted remand and let us have a second bite at the predicate apple.
But if we're under plain error review, and I don't mean to rush you, but if we're under plain error review, just assume hypothetically we are. I fully understand your argument that
Yes,
we
Your
should follow Ruth and that Ward is not dispositive because that's a career offender question and not an 851 enhancement question.
Yes, Your Honor.
But there's no, it would be hard, or is there an argument that any error here in not following Ruth is plain? Because we don't have any, this is at least an open question in the Fourth Circuit, isn't it?
It is not. It is
Okay.
not. I'm not sure, first of all, just procedure, I'm not sure they have argued what the court is. They're not even, I haven't seen a plain error argument, objection.
Right, I'm
in their
very
brief.
confused about
Okay.
everybody's argument on the standard of review.
In fact, their standard of review stipulates it's de novo. All right, but in any event, we have two opinions published by this court, Kukalong versus Barr and Bob versus Barr, in which this court, as a matter of law, has said 18.2248, the Virginia drug statute he was convicted under, is categorically overbroad. So it's plain.
But that's in the context of comparing the entire Virginia drug schedule with the entire federal drug schedule. And
Exactly.
that's not this case, right? The definition in 802 has 4 categories: narcotics, marijuana, depressants and stimulants, and steroids. And your client was convicted of Virginia Schedule 1 or 2, a drug somewhere on those two. So why aren't we comparing those categories instead?
Thank you, Your Honor, because the Virginia, we know through stipulation in their brief and through those two published cases by this court that the Virginia statute criminalizes conduct that the federal controlled substance statute does not. It's over, there are at least one or
Right,
more.
but the definition in 802 is not the federal controlled substances. It's not everything on the list. And your client was convicted of something on Virginia Schedule 1 and 2. So you're right about what our precedent says, but it doesn't win your argument.
Judge, I really think it does. And other circuits recently that have looked at the same
But
question.
so a felony drug offense means an offense that is punishable by imprisonment for more than 1 year, that prohibits or restricts conduct relating to narcotic drugs, marijuana, anabolic steroids, or depressant or stimulant substances. It doesn't say that is under the law of the United States, controlled substances. But it's a term of art there, and those terms of art are defined.
Those terms of art, yes, Your Honor, like narcotic drug is defined in 802. Elsewhere in 802, narcotic drug as used in that statute is defined in 802.
Okay, but Mr. Beers, why would the statute in that subsection 44 talk about prohibited conduct relating to? Seems to me that the language relating to is a very broad basket where Congress was trying to capture anything that met the criteria of more than 1 year in prison under a law that prohibits conduct relating to narcotic drugs. And how can you say that the 801-248 in Virginia does not relate to narcotic drugs?
Because narcotic drugs has a definition that we're supposed to use. Congress has given us. It's defined that term, Your Honor, and it's in 802. It's defining narcotic drug. And it's
So you're
defining-
saying relating to is essentially surplusage? It doesn't expand the concept of a felony offense?
Not outside the definitions Congress has given us. I mean, we have a federal statutory construct. There's no reason to start borrowing from different state definitions. Congress has
Well,
defined.
no, I'm not talking about borrowing from the state. I'm talking about the relating to seems to be a very generalized term in the federal statute.
It relates to, Your Honor, narcotic, which is defined federally. For example, to include cocaine, in the definition of cocaine in 802 is narrower, clearly, for example, than the Virginia.
No, I understand your argument. It's just, I guess, getting back to Judge Rushing's question, any law of a state that prohibits conduct relating to narcotic drugs. And you're saying that automatically refers to the federal definition.
Yes, and I think that's why we're applying the categorical approach They even say apply the conduct-based categorical approach as in Ruth. And I'm basically just presenting the Seventh Circuit's analysis. They cite not one case suggesting outside the career offender guidelines issue, which we're not talking about. They cite not one decision accepting their argument that we get to borrow from state definitions of narcotic drugs, that we're not bound by the Congress's definitions.
I'm sorry, one last question.
Yes, Your Honor.
So again, I'm just really wrestling with sort of what the context is for looking at these questions. The district court said twice, both at sentencing and then in the written statement of reasons, that with or without the enhancement, the 851 enhancement, the district court would have sentenced to life for these counts anyway, whether or not there was a mandatory minimum life sentence. Does that affect our review at all?
No, Your Honor, I don't think it does. And again, I haven't seen an argument like that in their brief, but I don't think it affects, not what we're talking about is statutory mandatory life sentence. I think if there's an error, this case needs to be remanded for complete reconsideration.
Make sure the district court. Okay, and just one last question.
Yes, Your Honor.
Does the career offender designation in this case make any difference to the sentence? Because I found the sentencing issue extremely complex, but the one thing everyone seems to agree on is that the fact that your client was designated a career offender under the guidelines did not affect the guidelines range, did not affect anything about this sentence.
You may be correct, Your Honor, but because I think this case, if my arguments on the merits are rejected, should be remanded, I wouldn't want it to go back with a finding that he's a career offender, and he's not. They didn't prove the career offender because that takes 2 controlled substance offenses, and the Maryland clearly doesn't qualify under Shepard. The Virginia may, but not the Maryland, because the Shepard documents don't even show that it's a drug offense.
But if hypothetically, and this is purely hypothetical, if that were the only error in this case, is that something we would correct ordinarily, given that it made no difference to the guidelines calculation or to any of the sentences?
I think so. If he's being enhanced as a career offender, I think it should go back for reconsideration.
But he wasn't. I mean, I thought you agreed his sentence was not enhanced as a result of that designation.
She found he was a career offender.
Yeah.
She found he was a career offender.
And then she said, but it makes no difference to the guidelines range in this case.
I thought what Judge Dillon said was, even if I'm wrong about the 851 for some reason, and he's not.
That too. She said both things, but the PSR says this, everything says this, that we're calling him a career offender, to be clear, doesn't affect his guidelines range. This is the rare case where it doesn't affect the guidelines range. I mean, I don't want to hold you up on this. I was just wondering, it is not your position that everyone has missed something and this actually did affect the guidelines range. Your position is we should correct it whether or not it affected the guidelines range.
Yeah, yes, Your Honor. But if we're not going to, if he's not enhanced for the 851 purposes, I think everything needs to be relooked at.
Thank you.
All right. If there are no further questions, this concludes appellant's argument.
Thank you very much.
Thank
Sorry
you.
I kept you up here.
Good afternoon, Your Honors. Laura Rottenborn on behalf of the government. I'd like to start where we left off with Judge Harris's question about the career offender enhancement. First, it is the government's position that both predicate convictions qualified for the career offender enhancement, and therefore it was properly applied. But regardless, Mr. Weisinger had an offense level of 43. And so to Your Honor's point, any error in applying the career offender enhancement would have been harmless. The guideline range would not have changed even if the career offender enhancement had not applied. But to correct my my opposing counsel's statement, the government does not concede that either predicate conviction was improper for the career offender enhancement. To the contrary, both predicate convictions categorically qualify.
But you agree that there's no Shepard-approved proof that there even was a Maryland conviction?
That is correct, Your
So
Honor.
how can it possibly qualify for career offender status?
Because you use Shepard-approved sources when the modified categorical approach is being utilized in order to determine what specifically the defendant has been convicted of, so you can match it on to the divisibility analysis. Here, however, in the career offender context, The question is whether or not there is proof by a preponderance of the evidence that Mr. Weisinger was indeed convicted of, for example, Virginia 18.2248. And if he was indeed convicted of that offense, and because this court held in Ward that it's a categorical match, not subject to the modified categorical approach, he then is subject to that predicate. And therefore, the only question is, was there sufficient evidence established by a preponderance of the evidence standard that Mr. Weisinger did indeed have that conviction? And in this case, there was. And in many cases, there is. For one thing, Mr. Weisinger did not contest it. It's listed in the PSR. He does not object to that conviction in the PSR.
PSR. So probation officers from now on will just decide what offense people have committed.
There's an obligation on the defendant to object if the PSR is inaccurate. And as this court has held in Terry and in other cases, when there's a fact in the PSR that goes unobjected to, the district court can use that fact to determine whether or not the fact has been established by a preponderance of the evidence, which here it has. And Mr. Weisinger, even on appeal, is not contesting that he was not convicted of those offenses.
I think, I mean, I'm looking at the transcript and the district court actually asked him, you have no evidence to present with regard to any denial of those convictions, correct? And he says, correct. So he didn't just fail to object. He affirmed on the district court's question that he didn't deny the fact of the conviction, but he is asking, he objects to using them for the enhancements.
Yes, Your Honor. He conceded he had the convictions. He merely disputed whether the convictions qualified as a matter of law. But there was absolutely no dispute, and there remains no dispute on this appeal, that Mr. Weisinger was in fact convicted both of Maryland distribution and Virginia distribution. There's therefore not a factual debate to be resolved on this appeal or on any remand. And because both Maryland distribution and Virginia distribution categorically qualify, there's no question left for this court to decide. The binding decisions of United States v. Ward and United States v. Johnson dictate that result with respect to the career offender enhancement. Now, I'd like to turn to the 851 enhancement, which is admittedly much more complicated. With respect to the definition of felony drug offense, which is the basis here for the 851 enhancement, it is an issue of first impression in this circuit whether the definition of federal drug offense requires this court, when the defendant is convicted under a state statute, to see how the state law defines both the punishment and the prohibited conduct, or whether this court should look to federal law for those definitions. Well, this court has already resolved that exact question in two other contexts. One, with respect to serious drug offense, which of course is the definition that provides an 851 enhancement.
I don't want to interrupt your train of thought here, but it's you just said that we don't have any precedent directly on point. And so Judge Harris's question about the standard of review, I think, is important. Are we doing de novo review of this question or plain error?
It's the government's position that with respect to the Virginia conviction, you are under a de novo review. Now, we vacillated on this internally because it is admittedly close, but we felt like the record needed to inure to the benefit of the defendant. He did not brief this issue in his objections. The defendant below only briefed the issue with respect to career offender. However, at sentencing, and at which point the defendant had new and different counsel, Judge Dillon asked the attorney, are you making this objection also in the context of 851? And Mr. Cook, the then sentencing attorney appointed for sentencing, said, yes, Your Honor. That's at JA 1253. And so the government, looking at the record in the light most favorable to the defendant on that point, decided to brief this issue on appeal under a de novo review.
But Maryland under plain error.
Yes, Your Honor, because he did not.
So that brings me back to my question. I don't understand this hybrid standard of review. I would understand it if you needed both predicates to qualify for the enhancement. But for an enhancement where you only need one predicate, and if the government has two and on your own account, you object only to one, how have you objected to the enhancement? I don't get it.
The government framed the plain error standard of review with respect to the Maryland conviction because the defendant did not object to that conviction, and yet there was no judgment entered. The government did not provide the judgment document to the court to prove that conviction. And so if you look at, if the question Your Honor is asking is, do you have to object to each individual predicate or do you object to the application of the enhancement? Then the question, then I believe we would be under de novo review for the same reason that we're under de novo review for the Virginia predicate, which is on JA 1253, the defense attorney at sentencing said, we are adopting our arguments that we provided in writing with respect to the career offender enhancement to the 851 enhancement.
So you read the defense counsel as having said, as to both Maryland and Virginia, we are objecting under 851.
No, Your Honor, because the objection to the career offender enhancement also did not include any objection to the Maryland conviction. At no point did Mr. Weisinger object to the Maryland conviction.
All right, I will let this go in 1 minute, but just so I am clear, the government's position is that if the government notices 2 possible predicates for an 851 enhancement, for which you only need 1, and the defendant objects to 1 of them, the defendant has effectively objected to the enhancement, even though didn't object to another one, which would be sufficient for the enhancement.
No, Your Honor, that's not the government's position. The government's position is that if you only object to 1 and there's still 1 left, and then you object to the enhancement on appeal, then you would be under a plain error review standard.
Well, isn't that exactly what you think happened here? That's what you just told me happened.
Yes, Your Honor.
So why aren't we under plain error? I'm just confused.
So you're under plain error for whether or not the application of 851 was appropriate.
Okay.
But then you break it down. In order to resolve that, you're looking at both convictions. And because the government has conceded the Maryland conviction, and we are only looking at the Virginia conviction, you have sort of a twisted legal application here. It's twisted because we are agreeing that the defendant preserved the argument that the Virginia conviction should not qualify.
Preserved an argument, but he didn't preserve an objection to the enhancement.
Yes, Your Honor, that would be correct. That's exactly correct. It is an extraordinarily odd procedural posture.
Agreed. I'm
Yes.
sorry, I've taken up too much of your time.
No, you're absolutely right. It's an odd procedural posture, and the government has tried to view the record favorably to the defendant. To be fair, given that it is a life sentence case.
Yes, and can I interrupt and say that I very much noted and appreciated your close read of the sentencing transcript.
Thank you, Your Honor. But I do think it's extremely important that the court understands that the argument the government's making and what we are asking this court to find as a matter of law is that with respect to a felony drug offense, that the court should apply the same reasoning and reach the same conclusion as it did for controlled substances offenses, as opposed to the conclusion that the court reached for serious drug offenses. So there are 3 different types of drug offenses, all of which can be predicates in different contexts. Serious drug offense is the predicate under 924E, both for armed career criminals and for 851 enhancements for drug crimes under 841A1A and A1B. Felony drug offense, which is the one at issue here today, of course, is the predicate for an enhancement under 841B1C, which is our case. And then, of course, controlled substance offense is an enhancement under the guidelines for career offender. And all 3 definitions are slightly different, but felony drug offense is much closer to the definition of controlled substance offense than it is to the definition of serious drug offense. And that is why the government's brief has explained that the reasoning in Ward should control the result in this case. When you look at the sentence structure for felony drug offense, it maps on to the sentence structure for controlled substance offense. It requires either a federal or state offense, or in our case, also a foreign offense, that prohibits certain conduct of a controlled substance. Now, in our case, the exact language is conduct relating to, and then it has 5 categories. For controlled substance offenses, it prohibits conduct of a controlled substance. But controlled substance for controlled substance offense is not defined. It is not expressly incorporating any particular schedule, and it does not expressly incorporate the Controlled Substances Act. That is the same in felony drug offense, where you have.
Stop you there, because that I don't understand, because felony drug offense, I mean, it lists out these 5 terms of art. Narcotic, it doesn't say controlled substances. It says instead of controlled substances, which is sort of a generic term, it gives us narcotic drugs, marijuana, anabolic steroids, depressant or stimulant substance, each of which is a term of art defined in the exact same statutory provision. So how can it, but your position is it's not actually referring to the definitions contained in the same provision of those 5 terms.
Not when it's a state statute predicate, correct, Your Honor. And that's because if you compare felony drug offense to
But-
serious drug offense, yes, Your Honor.
You didn't do this, I don't think, but I looked at Virginia law to see if they define these terms. And they define some of them, but not all of them. So how am I supposed to figure out, if a state doesn't have a definition of one of these terms? If I follow your approach, how am I supposed to figure out if something qualifies as a depressant or a stimulant or an anabolic steroid?
That's right, Your Honor. Virginia does define narcotics, for example. It's in the Virginia Code, and in this case would include the drug for which Mr. Weisinger had been convicted of distributing. But just like the court found in Ward, though a word that is not expressly defined in the Controlled Substances Act should be given its ordinary meaning. The opinion in Ward held that controlled substance should be defined as it would in Webster's dictionary, for example, which
That
is a
seems
substance.
a lot easier. Like a controlled substance is a substance that is regulated, that the government says you can't have, that it controls your access to. But, there's like 51 or 52 different approaches to what qualifies as a narcotic, or, which your opponent points out based on like isomers of this and that. And how are we supposed to know what the Webster's definition of like whether this cocaine isomer is included in a narcotic offense or not in the state of Virginia? Shouldn't we just look to the statutory definition?
Well, the state of Virginia does have a statutory definition for narcotics, and it includes Virginia's controlled substances. And so you would not have to be left wondering. With respect to stimulants or depressants, the ordinary meaning of those words is not that complicated. It's whether or
You're
not.
saying we would use it says stimulants or depressants or stimulants. And you're saying, don't just look at the exact same provision, which sets out the definition. A drug which contains any quantity of barbiturate acid or any of the salts of barbiturate acid. And then it goes on and saying, forget that. That's not what they meant. When they use that term in the exact same provision, that is not what they meant.
I absolutely think it's what they meant when the offense of conviction is a federal offense. So if the defendant is convicted of a federal drug distribution, then you would look at the federal definitions of narcotics, stimulants, depressants, and steroids.
But what do we do when the state doesn't have a definition? I know Virginia defines some of these terms, but what if a state doesn't define any of these terms?
If a state doesn't have a definition, for example, in its regulations or its code for narcotics.
Right.
It's the government's position then that you would apply the ordinary meaning of those terms,
What
just
does
like
that
they
mean?
did in Ward. I mean, Ward looked at Webster's dictionary to find that controlled substance is a substance regulated by law. The same could be true for narcotics, and then
What is the Webster's definition of narcotics? I'm unfamiliar.
I don't know, Your Honor. I have not looked at.
Seems like it'll be very important in this case.
Well, in this case, the narcotics.
Well, Virginia
were defined
defines
by
it,
Virginia
right,
code,
right.
So it wasn't applicable.
But I
here.
bet it's not as specific as most states' definitions of criminal offenses. I mean, whether you committed a crime can really turn on like whether the molecules are attached, on this part or that part of the chain. It's hard to believe that Webster's is going to give us a specific enough definition, and maybe Congress meant us to use the definition that they provided.
The key there, though, is we don't know because Congress did not say use these definitions. In serious drug offense, which is the enhancement for 841A1A and B and armed career criminal, that definition specifically says use the substances that are identified in the Controlled Substances Act. Use the definitions from the Controlled Substances
And they were
Act.
referring though to a different provision. I'm still hung up on the fact that right in section 802, there are definitions of all of these terms. Would Congress really have to say like, oh, it means the same thing here as it did in the prior page of the same provision?
Ward says yes to that question. Ward made the exact same conclusion with respect to the sentencing guidelines, because for a controlled substance offense, it has to be a federal or state offense that prohibits conduct of a controlled substance.
Goes
And
out of its way to say, look, there is nothing about this guidelines provision that in any way alludes to any federal definition. This one does, because it's all part of the same provision. This uses 5 terms of art that are all defined in the same provision. And it doesn't.
Yes, Your Honor. However, I would point out that the guidelines do have a reference to controlled substance. They have the drug quantity table. I mean, the federal controlled substances run throughout the guidelines manual. And Ward Court did not conclude that the use of the word controlled substance in the guidelines meant the federal controlled substances. It allows for state controlled substances. And importantly, that's because there's also a two criterion to the definition. A controlled substance offense, just like felony drug offense in this case, require two things to be proven. One, that the crime is punishable by at least a year. And two, that the offense prohibited conduct relating to one of the 5 categories. And the Ward Court held that you would not look with respect to the first criterion to federal law. So if somebody's convicted of Virginia distribution, you don't find an analogous federal statute to find out whether or not it would be punishable by more than a year. Instead, you look to the state law to determine whether or not the state crime is punishable by more than a year. So if you're going to look at the state law for the first criterion, why would you not look at the state law for the second criterion in the absence of explicit direction from Congress otherwise?
I don't want to short circuit your argument, but do you have a fallback argument about whether, if we do look at these federal definitions, whether the enhancement would still apply or the mandatory life sentence would still apply?
Yes, Your Honor. Obviously, the Ruth Court found that if you apply the federal definitions, the Illinois distribution statute did not apply. Here, that this court should not reach the same result. One reason is that Virginia distribution does not read the same as Illinois distribution. Illinois distribution specifically criminalizes the distribution of positional isomers. The Virginia distribution statute does not. It talks about cocaine and its isomers thereof. It does not include positional isomers. And there is absolutely no evidence in the record that a positional isomer of cocaine is even a real thing. An internet search or look at some of the district court cases, for example, in our own district, show that this is a question of fact. We are currently briefing this in our own district with chemists from the University of Virginia who are serving as experts to explain what the isomers of cocaine even are. And so there's an open fact question as to whether or not when Virginia distribution statute criminalizes cocaine and its isomers, what that even means. What are the isomers?
Are you aware of any Virginia cases about isomers of cocaine or isomers of heroin?
Yes, at the district court level. Yes, Your Honor.
In federal courts, but not any Virginia state court cases?
I am not aware of any state court cases resolving the question of what cocaine and its isomers thereof means as a matter of law in Virginia. No, Your Honor. I'm happy to research it and provide supplemental
No,
briefing.
I didn't find any either, but I thought, I'm sure both of you probably looked into it. So I wanted to make sure that, I was aware.
I'm not aware of any state guidance on that point. I am aware, however, that we are litigating this in our district courts, and it is certainly highly questionable whether or not there can even be such a thing as a positional isomer, let alone a positional isomer of cocaine. And to the extent that the Virginia distribution statute criminalizes distributing cocaine and its isomers, there is nothing in the record to show that cocaine's isomers are not also covered by the definition of narcotics and stimulants within the meaning of 802, Section 802 of Title 21. And to that extent, the government's argument would be that because the clear definition of cocaine and its isomers could fall under narcotics or stimulants, then on this review here, there's no reason to reverse. But in the worst case scenario for the government, a remand would be appropriate for fact finding on whether or not cocaine and its isomers all qualify as either are a narcotic or a stimulant within the meaning of Section 802 of Title 21.
If the worst case, this case is deeply complex. If we would otherwise be compelled to remand for fact finding on cocaine and its isomers, would it matter that the district court has already told us with or without this enhancement, the sentence is the same? Would we still require the district court to do a fact finding into isomers if it doesn't affect the sentence?
Yes, Your Honor, but then a no. Yes, because I don't think you can have an applied 851 enhancement stand as a legal sentence if the 851 enhancement is not proper. And so even though Judge Dillon may very well sentence Mr. Weisinger to life no matter what, I do believe it would be an illegal sentence if it was based on the application of an improper 851.
And it's kind of
However,
the continued complexity, right? The reason we don't have evidence about this is because this objection really wasn't made below. Instead, it was a career offender objection that just kind of was said, oh yeah, and that applies to this enhancement too. But in fact, they're completely different arguments.
that's exactly right, Your Honor. And that's sort of why we're on a merry-go-round here. But I would emphasize that if this case gets remanded, the Maryland conviction will be proven. The Maryland conviction, we have the judgment for, it was inadvertently not provided to the court. And so the great irony in all of this is if we go back, the government will offer up the Maryland judgment. The 851 enhancement on Maryland will apply, which is not subject to this exact same problem. And so it's the government's position that eventually the same outcome will be reached. It's just the machinations of how we get there.
Okay, counsel, I have a question going to the other part of the definition of felony drug offense, which says, refers to an offense that is punishable by imprisonment for more than 1 year. Is it your position then that we have to look whether it's punishable by imprisonment for more than 1 year under the federal statute as defined in the terms listed later on in the statute? Or do we look to punishable by imprisonment for more than 1 year under state law?
The latter, Your Honor, consistent
Okay.
with Ward. And Your Honor, that's exactly why, because you're looking to state law for the first criterion, it's the government's position you should look at state for the second criterion when the predicate offense is a state offense. That it would be unprincipled to look at the state law for the first criterion and not look at it for the second criterion.
Okay, why would it be?
Why would it be unprincipled to, the Ward court explains that that when you're looking at the two criterion, because under a controlled substance offense, it has the same two criterion as felony drug offense, that there's no question you should look at the state law to see if it's punishable by more than 1 year.
Okay, it just seems to me that, and if you could help me with this, that what you're really saying is that it's more logical to look to state law throughout, because we know we look to state law in the beginning in terms of the length of punishment, right?
Yes, Your Honor.
And there's nothing particular in the wording of 44 that says you've got to look at the federal definitions. It just so happens that there are federal definitions for those terms. Is that your best argument?
That's exactly right. And I would add to that, that the wording of the definition is important, that the Ward court found that when it stated that it's an offense that prohibits conduct related to a controlled substance, that the preposition ties back to the offense. And so when you read the language of the definition, they're saying whether it's a federal offense that prohibits conduct of a controlled substance or a state offense that prohibits the conduct of a controlled substance. And I'm using conduct as shorthand for manufacturing or distributing or PWID. And so when you read the clause in its entirety, it can be read to indicate that what was meant is that you look to see whether the state is trying to criminalize a narcotics offense or whether the federal government is criminalizing a narcotics offense. And when the defendant is convicted of a state narcotics offense, it should qualify as a predicate. And that's really in the spirit here too of the congressional intent behind the enhancement. I mean, it would eviscerate congressional intent to find that all Virginia drug distribution felonies don't count as a felony drug offense. Clearly, the intent was to capture state distribution offenses. And so by requiring the felony drug offense to be both punishable by more than a year and be an offense that relates to conduct involving narcotics, stimulants, depressants, and steroids.
Why isn't it just phrased like the guideline then that Ward was addressing? I mean, I know that's unfair to ask because that's asking to speculate about why Congress did it, but I mean, it's much clearer to say, you know, a state law relating to controlled substances, and we know we're looking to state controlled substances.
Yes, I think we all wish Congress had been more clear in how it defined this. And surely had they said controlled substances under either federal or state law, then we wouldn't have this debate. But the very fact that there's ambiguity means that the statute, or in here the definition, is not unambiguous, and congressional intent should therefore matter. And the ambiguity that exists in the definition of federal drug offense as to whether or not you call on the federal definitions or the state definitions when it is a state offense should then lend itself to an inquiry as to what Congress would have intended here. And when you have a reasonable choice between two interpretations of a statute, one which would eviscerate congressional intent and one which would effectuate congressional intent, the government would urge the court to adopt the interpretation that effectuates congressional
There are
intent.
two reasonable interpretations of a criminal statute. Don't we usually take the one that's more lenient toward the defendant?
No, Your Honor. I believe when there's ambiguity in the statute, then it would be proper to look at other sources, both for congressional intent and.
What about rule of lenity, though? Doesn't that come into play at all?
In Schuler, the Supreme Court rejected the application of the rule of lenity when deciding serious drug offense. I would need to go back and refresh my memory.
Yeah,
on
could you
the.
direct us to the particular language that you're talking about?
Yes, Your Honor. I did not prepare on that issue. I do remember reading it in Schuler, but my recollection is that it is. It's in Schuler, starting at pin site 787. Yeah, okay. So it talks about when the rule of lenity should apply, whether, and in that case, the court concluded, of course, that the conduct there was not ambiguous. And so it did not apply the rule of lenity. So to your point, Your Honor, if
Okay, which conduct then are you talking about?
in Schuler, the issue was the definition of serious drug offense, not felony drug offense. So the 851 enhancement for 841A and 841B. And the question was the language in serious drug offense and whether or not it left doubt that the offense involved the conduct, and they say conduct because they're trying to decide whether or not the conduct-based categorical approach applies, of manufacturing, distributing, PWID, et cetera. And then the court concludes that because those terms describe conduct and do not name offenses, then they would not, then it is unambiguous and the rule of lenity would not apply. So to your point, where there is ambiguity, then the rule of lenity may be implicated.
If we adopted your interpretation of this definition of felony drug offense, we would be splitting with the Seventh Circuit in Ruth, right, on the definition.
You would be coming to a different conclusion. With all due deference to the Seventh Circuit, they did not analyze this. They just simply came to the conclusion.
We can do that, but I was just wondering, are there any circuit courts that have come out the other way, sort of have adopted your definition? It seems like we are a bit of an outlier, even under the guidelines, right? Most circuits have adopted the Jerome presumption that even the guidelines require a match with federal definitions. And so if we go one step further and say, also, you don't need a match with the federal definitions under 802.44, we'd be breaking with Ruth. Would we be with some other circuits?
No, you would not, Your Honor. You would not be with any other circuit. And to the best of my knowledge, you would not be breaking with any other circuit. Excuse me, you would not be joining any other. You would neither be disagreeing nor agreeing with any circuit other than the Seventh Circuit.
Right.
I believe the only court to have addressed this issue is the Seventh Circuit in Ruth.
Right.
Now, there is the Oliver case out of the Eighth Circuit that Mr. Weisinger cites, but that is applying the Illinois distribution statute. So it is, they simply adopt Ruth there. They don't.
Ward itself is a bit of an outlier, right? More circuits have gone the other way.
There is a circuit split on the issue resolved in Ward. That's correct, Your Honor.
Okay.
Of course, in this circuit, Ward is binding precedent.
I understand, but this would be a step beyond Ward.
This would be applying
into-
Ward to the context of federal drug offense and rejecting the approach of the Seventh Circuit, at least with respect to the conclusion it reached. It did not provide any analysis on this point. It provided extensive analysis on deciding the 851 question. Excuse me.
Ward question.
Yes, but then it just simply applied the federal definitions without any analysis. And I would emphasize here too that not only did they do it without any analysis, when they cite the federal definition that they're comparing against, the court first cites the Controlled Substances Act, not the definition for narcotics, stimulants, depressants, or steroids. And so to the extent that they are suggesting that there should be a comparison to the Controlled Substances Act, i.e. the Controlled Substances Schedules, that is flatly wrong, and we would discourage this court from adopting that approach. It looks like the Seventh Circuit's fallback position was to compare the state offense to the federal definition of narcotic. It did not do any analysis with respect to any of the other subcategories. There was no analysis as to whether, for example, a positional isomer of cocaine might qualify as a stimulant. So there was just absolutely no analysis in the opinion. It was a mere conclusion at the end. And because it concluded with a citation to the Controlled Substances Act, the government would suggest that it wasn't a sufficiently thoughtful conclusion that warrants deference in this case. And we would encourage the court to look at that issue anew. I am way over my time. If there are any additional questions on any of the other issues, I am more than happy to address the other issues.
Thank you very much. We appreciate the extra time.
Thank you, Your Honors.
Great. You have time for rebuttal, Mr. Beers?
Thank you. May it please the court, I appreciate the time for rebuttal. I'd like to make 4 points. I think the first is the rule of lenity was very much reaffirmed by Justice Gorsuch in the Davis case the year prior to Schuler, which really is the leading case on the modified categorical approach. Judge, you would be breaking with other circuits. I mean, not just the Seventh. Ruth was even closer than this case because in Ruth, at least the state Shepard-approved document showed it was cocaine. In this case, we don't even have that. So you would be, there are a collection of cases that emerged in the last 2 years that are right on point. There are 3. The Eighth Circuit, same facts. You can't tell from the state Shepard-approved documents what the substance is. You'd be breaking with the Eighth Circuit. That's 2021. You'd be breaking with the Third Circuit in Aviles, which is all cited in my reply brief. Third Circuit 219, same facts. And I think Thompson, the Second Circuit 2020, which is also cited on page 17 of the reply. So you would be breaking. And I think as they've candidly said, no court has adopted this argument they're making. Ms. Rottenborn is, again, talking now, she's talking about positional isomers and isomeric this and optical isomers. We don't get to all that because as a matter of law, we know from Kukulon and Baugh and their stipulation in their brief that the Virginia statute criminalizes drug-related conduct broader than the federal statute. So that's the end, should be the end of the discussion. That's the whole point of the modified categorical approach, is to make things simple and straightforward. I think Justice Gorsuch makes that point in Davis. And they're trying to complicate things by talking about isomers, but we know here that the statute in Virginia is broader, and therefore there's categorical overbreadth, and it's over. It's not a qualifying predicate. They're trying to undermine the categorical approach, the simplicity that this categorical approach brings us by talking about chemistry and its state definitions. As far as the standard of review, Judge, yes, I mean, as criminal defense lawyers waive things all the time, and it's uncomfortable on appeal when that happens. Well, they, in their brief, have made, for their own reasons, ethically, I think maybe strategically, they have decided this is a de novo review, and I would ask the court to consider that. They have waived any right to now argue otherwise, and I would think we're here on de novo review because of that. Finally, I'd like to go to the colloquy between Ms. Rottenborn and Judge Rushing about whose fault this is, and that implicates the scope of the remand that I hope we're going to have. It's yes, trial counsel for the defense missed some things, but they did too, all right? So the United States Attorney's Office had all the documents, and they understand, because they're super bright, just as these two lawyers are super bright. They know, because they go to trainings all the time in Columbia, South Carolina, and they've clerked for federal courts. They know what a Shepard-approved document is. And we have no explanation here, except they just say we had them, but we just submitted the wrong documents or something. So on those facts, where there's no deus ex machina, no intervening cause, no change in the law, it's simply an issue of fact. They had a burden to carry below. And that was to introduce Shepherd-approved documents for these predicates, and they blew it. They were remiss. And on that very simple set of facts, I think the case law in this circuit is clear. They don't get a second chance. As you hear them saying, oh, all these machinations Mr. Beers is making us go through, we're just going to do it to his client again. We're going to do a better job. They shouldn't have that second chance. That's a very important issue here. Mr. Weisinger has taken them on appeal. And if you find that Mr. Weisinger is correct, it should go back perhaps, but it shouldn't go back with them getting a fresh opportunity to do what they should have done the first time. They should be incentivized. I hate that word. They should be given an incentive to do a better job to begin with. Thank you very much.
Thank you both. We appreciate it. Mr. Beers, we know that you were court appointed and especially appreciate your efforts today. Thank you. We are sorry we are not coming down to greet you in person, particularly after this marathon session. We wish we could say thank you face to face, but we very much appreciate your help today. uh, 1311, Uncork and Create. And Mr. Martin, it sounds like you're first.
Good afternoon, Your Honors. May it please the court, James Martin for Appellate Uncork. The coverage issues in this case obviously are part of a nationwide controversy on the construction of all-risk business interruption insurance policies. But this court's task is not to resolve that controversy or to settle a debate over which line of case authority has the right analysis. Instead, the analysis that this court must undertake is how West Virginia, applying its policy construction principles, would construe the policy language in dispute. And if this court ultimately concludes that the coverage issues raised are so significant and important as a matter of public policy that it would benefit from guidance from the West Virginia Supreme Court, it can certainly certify the issues there. But either way, what has to be settled is West Virginia law and only West Virginia law. Now, in a West Virginia policy construction dispute, my client, Uncork, and the insurer, Cincinnati, have very different burdens where the policy language is concerned. For Cincinnati to prevail, it has to establish that the relevant language in the policy clearly and unmistakably supports the construction it offers. But equally importantly, it also must establish that the language supporting the construction is unambiguous and it's the only reasonable construction possible. For Uncork, the burden is not nearly so steep. My client simply has to offer a reasonable construction among the many constructions that might be possible. It doesn't have to be the only one, and it doesn't have to be the best one. And accepting Uncork's construction does not mean that Cincinnati's construction must be deemed implausible or even that it must be rejected. It only needs to show, that is Uncork, that the events and conditions that result in the claim for coverage fit within the ordinary definition of the policy terms. And as our briefing makes clear, given the language used, which is not a model of clarity, and West Virginia case law, which favors a construction in a coverage case for the insured, and with the Murray and Chafin cases, we submit there is ambiguity in this policy. And in the face of that ambiguity, an ordinary insured could read the policy to extend to a complete loss of use of the property for its intended business purpose for the reasons Uncork has explained. By the same token, this policy language.
Can I ask you about that loss of use?
Yes.
What if, and I understand this is not the case, but what if your client operated a pharmacy or a hardware store, something that the governor considered essential, unlike a paint and sip, which he did not consider essential? The governor, if it was a hardware store or a pharmacy, could your client still have operated in the office space?
Here, the answer to that is no, Your Honor, and it's unequivocal. So as a result of the presence of the virus and the spread of the virus, the transmission of the virus, and finally the closure orders, there was no option for Uncork to operate.
I know Uncork couldn't operate a paint and sip business, but what if instead Uncork was a hardware store?
Oh, excuse me. Well,
Sorry
in
about
those
that.
circumstances, if the property remained open and could be used for its intended purposes, we wouldn't be talking about business interruption coverage or the suspension of use of the property for the purpose, so that it could work for
So
that.
I'm wondering, because of that, if that indicates that it's the kind of service that your client provides that was prohibited, that kept them from operating. It's not the physical space. There was nothing about the physical space that prevented them from operating. It was the type of service they provided there that they could no longer provide there.
So two things on that, Your Honor. The type of service does matter for purposes of this insurance. After all, Cincinnati wrote a policy for my client, and we paid an extra premium for the business as a going concern, the way that it operated for its intended purpose. So intended purpose does very much matter here in terms of the coverage. And for the
I'm wondering
physical,
about how that goes to the meaning of physical. Yeah.
Okay, so for physical, we are looking at the ordinary definition of the term, which means something tangible. And here we're talking about the brick and mortar space and the loss of use of the brick and mortar space. This is very much a physical limitation. We can't hold events in our space.
But you could open a hardware store
Well-
or a pharmacy, or you could use it as an office, right? Someone who owned Uncork, if they just wanted to make it their personal office, just for one person to sit in all day and,
Right.
make phone calls and write letters, they could have done that. They just couldn't operate the kind of business that they wanted to operate there.
As I said, Your Honor, that would betray the purposes for which the coverage was purchased.
But is that
excuse
right,
me.
counsel? Because the provision doesn't seem to contemplate sort of regulatory restrictions on use. I mean, what if it were a hardware store? But there was some executive order that said you can stay open, but only 2 customers at a time. So you wouldn't be able to use it according to its intended use, which was to have more than 2 customers at a time, and there would be a loss of business income. Would you think that would be property damage?
So, Your Honor, what we are talking about here is the interruption of the business, not property damage directly.
Okay, so in my hypothetical, your
In
business would
your
be interrupted
hypothetical,
and
the
it would be
business
covered.
is not completely shut down, which Uncork's business was. As to the alternative use, that isn't what was insured. Nobody said we'll pay Uncork and Uncork should pay a premium for a coverage where it's not event space. That's how the premium was set. That's what the policy was about. On the physical side of it, the property was physically lost to Uncork for its intended purpose. And under the Murray case, I'm
Excuse me,
sorry.
Mr. Martin, what if the governor had just said you can't use this as an event space 3 days a week? Okay,
Right.
would there be a physical loss then?
So that would not be a complete physical limitation on the use of the property. And it would be a different situation for purposes of coverage.
But then doesn't that get you just back, if you need a complete physical limitation on use of the property, why isn't that just back to Judge Rushing's question? You're allowed to use the property. You can go there every day. You can do whatever your inside office work is. It's fine. Use the property. There's nothing wrong with the property.
Well, as I said, Your Honor, that would betray the purpose for which the coverage was purchased. The coverage, the business interruption portion of this policy, the business income portion of this policy.
It's not an insurance policy against business interruption. It's an insurance policy, as I understand it, against physical damage and loss. And in it, then there's this extra provision where in addition to actually replacing or repairing the physical damage, you will also get coverage for a suspension of business that results from that physical loss. So not only will they buy you a new furnace, but they will pay you for the 2 days you had to shut down because you didn't have a furnace. But it's not general business interruption insurance.
No, but Your Honor, when it comes from a non-structural event or set of conditions that make the property unusable, Murray tells us that is a definition of physical loss under
Okay.
West Virginia law.
But what about the fact the policy refers to other terms like period of restoration, loss to the property as a
Right.
premises? What is the period of restoration under your viewpoint?
So 2 things there, Your Honor. Again, from the perspective of the ordinary insured who purchased a business interruption policy that starts with the physical loss as Murray contemplates it and is unusable, we have the triggers for coverage. On the perceived tension between restoration of the property and the provisions for loss of income where the property can't be used, ambiguity abounds in those provisions as well, and it is not necessary to read them to defeat coverage in this instance. And remember, West Virginia law will not do that unless it clearly and unmistakably is required by the policy language, not by rewriting it, not by redrafting it, but by what it says. Now, for the repair and rebuild language, Your Honor, that only applies in circumstances where a repair, rebuild, or replacement will be necessary. It doesn't affect the business loss of income coverage under the interruption portion. So to begin with, West Virginia would not make that part of a contextual construction. The second piece of the restoration language is that it's a timing issue. It's not a threshold coverage issue. It's a timing issue. So if there is a need to repair, rebuild, or replace, that provision sets a time limit on it, but it doesn't vitiate the coverage triggers in the first instance for business income. And finally, as we have pointed out in our brief, starting with ordinary definitions that a reasonable insured would embrace, repair, rebuild, or replace can fit the restoration of the property for its intended use after its suspension. Those terms do not have to be read to involve physical repair. And let me go back to where I started. They can be. We are not disputing that. The issue is, do they have to be in the context of this policy? And the answer is, the policy doesn't clearly and unmistakably say that. And there is a construction, as we have offered, where an ordinary insured would say, my physical space has been lost to me by these closure orders. I cannot use it for the purpose that was insured under the policy. And that meets the definition of direct accidental.
I thought the policy covered lost income during the period of restoration. And I take your point. Well, say you don't need repairs and all that. Maybe it doesn't apply, but what's the time period under your theory? What's the time period during which the insurer must pay for the loss?
It's very straightforward. It's the closure of the property and the unusability of the property. That's the triggering event on the front end, which came from the presence and transmission of COVID and the closure orders. And the period of suspension or restoration back to intended use comes about when the property is usable again. Here, that was about a 2-month period, I think, for one of the properties. So was there a suspension of the intended use? Yes. Did it involve non-structural damage? It did, but Murray says that's not essential for physical loss. And at that point, I believe, Your Honors, there's at least 6 reasons a West Virginia court wouldn't narrow this policy down. The first one is,
Before you get to them, I just want to make sure I understand the rule you want us to adopt is that when a regulatory change makes property unusable for its intended purpose, there has been a physical loss.
right.
Okay.
There's a physical loss to uncourt.
Okay.
Its operations cannot be used
Got
as
it.
it
So
intended.
your answer is yes. Okay. So would that apply also to zoning changes? Like if the government had just said through some zoning change, Uncork is now located in a purely residential block, so you cannot use it for its intended purpose.
So our argument doesn't go that far.
Well, why not? What's the
Because the physical limitations here exist on the use of the space as a result of these closure orders. That's the direct connection.
I don't understand that. I'm
Well,
positing
right.
a
So-
zoning order that has the exact
Yes.
same effect. So tell me why they're
Yeah,
different.
So the zoning change could conceivably meet the definition of the policy if not excluded, but we don't have to go that far.
And tell me what your limiting principle is.
Okay, the limiting principle is the same one adopted in Murray, where the physical limitations that are imposed by the event or condition make the property unusable for its intended purpose. In Murray, it was a residence. Here, it is as event.
And in my
space.
hypothetical, it's a zoning order. I'm not seeing the limiting principle.
Well, if the zoning order is not going to permit us to use it
Right.
for its intended purpose, there could be the potential for coverage in that
Okay.
instance. But we don't have to go that far.
I think you do.
Here.
I mean, I think we've just established that you do, but that's fine. So your position is any regulatory restriction on intended use. It could be a zoning order, it could be a curfew order, it could be
No,
a capacity
Your
order.
Honor, I don't want to go that far, as
No,
I
I know you
said.
don't, but
This ordinance this issue in this case is aimed at the physical space directly. It's closed and it can't be used, period, for its intended purpose, right? And so it's the direction of the events and conditions at the physical space itself that is the distinguishing feature here, and it is the limiting principle, just as it was in Murray.
Yeah, let's get back to the policy term. What about direct physical loss?
Okay, right, so
Yeah,
let's,
because
let's,
that's what, that's our starting point.
No,
You've led us really,
yes.
really far afield, I think.
Well, I don't think so, Your Honor.
No, I'm not saying
Okay.
you're distracting us, but I'm saying we've really got to
Right.
focus on
So-
the ambiguity of the policy term
Yes.
itself. So perhaps you could wind up
me
by
go-
telling us
Let me go.
what
right
is
there.
ambiguous based
So-
on your theory of the case.
Under the policy, the coverage triggering event requires direct accidental physical damage or accidental physical loss to the insured premises. Now, there are no policy definitions for any of that, not for direct, not for accidental physical damage, or in the alternative, accidental physical loss. So what would a West Virginia court do? It would look to the ordinary meanings of those terms. So as far as direct is concerned, we have a direct line from the existence of the virus to its transmission and spread to the closure orders, which closes our business. So direct is met, and in fact, there's no contrary argument being made. Loss in ordinary parlance is defined as deprivation or the inability to utilize. And here, Uncork plainly was deprived of that. It couldn't use its business for its intended purpose.
Right, but physical is an
Right.
adjective.
So the
Is it
physical
not?
piece, Your Honor, relates to the brick and mortar premises where Uncork operates. The shutdown of Uncork's business was a physical limitation on the use of its space. The space was physically lost to Uncork. Its operations were physically suspended, and the property had no functionality for its intended use. So we're back to the relevance of intended use. And under West Virginia law, we know that's important because Murray tells us it is.
Murray's not about a regulatory restriction, a temporary regulatory restriction. It's about an imminent physical threat. Those seem really different. I'm having trouble reading Murray to address the effect of regulatory restrictions.
So
Because it would be, and I think you've not quite conceded this, but our colloquy has fleshed out that you don't want to have to really say every regulatory restriction is suddenly covered by property damage insurance.
no, but I don't have to, the burden that I have to assume, I believe, Your Honor, is to bring the policy language and its ambiguity to bear so that my fact pattern can be covered.
Can I ask you
Now,
a
and
question about the policy language? I'm looking at the business income, extra thing. And it says that what you need is there has to be a suspension of operations
Right,
that was caused by a physical loss. And so you want to use the same suspension of operations for both of those things, right? It's just, there's one suspension of operations. That's the first suspension of operations, and it was caused by a suspension of
it was
operations.
caused by events or conditions that meet the definition of physical
Right,
loss.
but the other way of putting that would be you have sustained a suspension of operations as a result of a suspension of your operations by the
look,
order. Doesn't that seem sort of strangely circular to you?
Your Honor, this entire policy is strangely circular. Try reading it all together with the definitions plugged in, and you will find that it is circular as to suspension, but that's not my issue. That's
Well, I
the
think-
drafter's
But I guess
issue.
what I'm getting at is it seems like the policy contemplates two different things, a suspension and a physical loss. And if it contemplates two different things, I'm having trouble seeing how the same thing, a suspension order, can satisfy both prongs.
Okay, so it is more than the closure orders, Your Honor. It's the events or conditions that lead to the closure orders. It involves, first of all, the existence of the disease, the threat of the spread, the transmission, and that results in the closure orders. So we have on the continuum a direct series of events that provide for coverage. Back to Murray for a minute, Your Honor. There are lots of ways to read Murray, but the important thing are the two things that the court actually said, that physical loss may exist in the absence of structural damage to the insured property.
Okay, but at that point, there was no access to the property. I mean, there was expert testimony, wasn't there? The boulders going to come crashing down?
So that was the second piece of it, that the property was rendered unusable. And remember, in Murray, that was for a residence. The court didn't say, well, it's usable for storage or anything else. The issue was, as a residence, the same analysis that we are presenting here. So now we're back to, what would a West Virginia court do? Would it adopt a limiting construction of this policy language to defeat coverage for the insured? Well, I think it wouldn't, and here's why. First of all, Murray starts us down the path of saying that there could be coverage, and so there's no reason to think that another principle of West Virginia law would emerge. Second, back to Your Honor's point on zoning and the rest of it, nothing in the policy expressly excludes the causal chain of event that renders these premises unusable. There's no clear and unmistakable language that says that. Without that specificity, West Virginia is not going to adopt a narrowing construction. It's not even going to look for one. And it's going to read it in light of dictionary definitions and what they compel. And as I said, we can fit within dictionary definitions here. And finally, West Virginia's courts won't redraft the policy, and they will credit the conflict in the cases, which have gone both ways. That's the Chafin case. So that gets us to the point, Your Honors, of ambiguity and the potential for coverage.
Thank you
Thank
very
you.
much.
Good afternoon. If the court please. My name is Daniel Litchfield. I represent the defendant Appalese, Cincinnati Insurance Company et al. I think we have a pretty stark contrast here between two different ways of looking at the same language. But it's important to start with the understanding that this is, after all, a commercial property policy. As has already been observed, we're talking about the need for a suspension of operations. Then the policy quite clearly says that suspension has to be caused by accidental direct physical loss or accidental direct physical damage. Then it goes on to say that the business income coverage, not business interruption coverage, which implies something quite different, but the business income coverage is payable for the period of restoration, which the policy says is the period of time it takes to repair, rebuild, or replace the property, or to establish the business at a different location. So the contrast is that Cincinnati sees this as an important opportunity to read this policy in context. And there are two levels of context that are critical. First, the context that this is a property insurance policy. So the term accidental direct physical loss or accidental direct physical damage has to be read in the context of the overarching fact that this is a commercial property policy. And then those words themselves need to be read within context, those words amongst each other in context. Uncork presents a number of techniques to try to eliminate context, and particularly to eliminate any use of the word physical in the phrase direct physical loss or damage. But the order at issue, which is alleged to be the cause of their issues, permitted the use and occupancy of the premises, just no customers on site, clearly directed to the idea of keeping people apart, social distancing, particularly very early in the pandemic. This is an order back in the spring of 2020. After the order lapsed, new orders came out, and ultimately everything went back to where it was. At the very least, there were suggestions that people clean and disinfect, and that there be social distancing or use of masks. But other than that, right back to where they started. That works contrary to the idea that there was some cataclysmic physical problem with the space. Rather, it was a different kind of problem again. So At net of this order in West Virginia, no buildings got rebuilt because of it. No tables or chairs were replaced. No walls were torn out. It's very different from the situation, for instance, with asbestos, where walls get torn out because the asbestos is on purpose part of the construction of the structure. That's the problem in these asbestos cases. This is something yet again. The trial court and Cincinnati are proponents of established West Virginia insurance law principles. These are stated in Murray and were followed by the court below. Murray was factually distinguishable according to the court below, and I'm here to explain the reasons why it is factually distinguishable. Also important to note that during the course of this order, even though there were restrictions on the use of these particular premises, people were still other places. They weren't put out into the woods, into tents. They were in structures. They were in buildings. That works against the idea that this can be transmuted into some sort of physical property problem rather than what it truly was. So what are those basic West Virginia principles? We're challenged to make this about West Virginia, and that's important to do. Among them, we've noted the plain and ordinary meaning rule, and that's based on the Saliva case, which is followed in Murray, and which was expressly followed by the trial court below. One should not define terms out of context. Context is important, and that's the Glen Falls insurance case, Glen Falls versus Smith. To have an ambiguity, it's been conceded that the alternative meaning must be a reasonable meaning, not just any meaning that one could come up with. The court is supposed to read policy to avoid ambiguities and not work the language to try to create them. And last, the court cannot create a new contract using these.
Can I ask you about,
Yes.
I guess, how those principles apply here? Because we do know from Murray that a physical loss doesn't require, a change or alteration in a building's structure. So it seems clear that under West Virginia law, at least some forms of kind of physical dispossession may amount to a physical loss. So what do you think is sort of the limiting principle in West Virginia law on that kind of physical loss by dispossession? What's required for that we don't have here?
I think it's stated in Murray, which there has to be permanent disposition. The distinction between this case and Murray is that in Murray, those three homes sat at the foot of this tall wall, which was engineered and which boulders were falling off of. It hit two of the three homes. One of the issues in the case was the extent of the insurance payment that should be made for the two that were hit. Should it be for the holes in the roof and damage to the siding, or should that be considered to be a total loss? And what the court held was it was uninhabitable. As a matter of fact, for the family that had the house that had not been hit, the fire department came and told them, you're out of here. You can't live here. And they never lived there again because that home was uninhabitable. Now, Murray, deals with a number of issues, and it's fascinating to read.
I just want to make sure I understand what you're proposing. So you said two things, that in Murray it was permanent and that the premises were entirely uninhabitable. Are those sort of two different conditions you would put on that dispossession form of physical loss?
Yes, and I would concede that they could exist in tandem in many instances, but I could conceive of instances where you have one without the other. But the key is the permanence and the key is the disposition. And I think that's how Murray is seen by other courts. For instance, in the Santos decision from the Sixth Circuit Court of Appeals, a very recent decision, it extensively discussed Murray and a number of other cases in what I would call the Murray genre that were cited to that court. And what Santos tells us is that Murray and those other cases, all of which I think are relied on by Uncork here, do not establish that you have the direct physical loss or damage that's required for this coverage. I think what the court said in Santos, and this may be close to a direct quote, is in those cases, they can't use the property ever again for anything. And that's a distinction with a very big difference from the facts of this case. The complaint here merely alleges that the virus is everywhere, it's ubiquitous, and there's this order. And the order did not allow us to use our property as fully as we wish to use it at the time when we wish to use it. And I think that's very different from Murray. Also, the physicality is not here as it was in Murray. In Murray, you had the wall there. You had the boulders coming off the wall. You had the reports of the engineers about that whole dynamic. And you had the engineers saying, with their stamp on the report, that these boulders will inevitably continue to hit these houses. People can't live there. And they didn't anymore, and they never returned. So I think that's an important limiting principle, and one that is consistent with the decision by the court below. That is that Murray would not allow this complaint to get any further than a Rule 12b6 motion. Murray started by looking at single words, the word landslide and the word erosion. And in interpreting those words and what they meant, what did it do? It didn't jump to the idea that, well, there's some sort of conflict in the cases. So as a result, we go right to ambiguity and the policyholder has coverage. No, not at all. What they did is they looked to Eighth Circuit cases and Ohio cases and a treatise to determine what the word landslide meant. And they looked to cases from out of state to determine what the word erosion meant. They then moved to concurrent causation by negligence, because one of the things that was going on in Murray was that there were allegations that that wall behind these houses had been negligently designed and negligently built and negligently maintained. And they had to sort out how those concurrent causes could have an impact on the coverage issues before the court. What did the court do to sort that out? It looked to a Minnesota case, which it described as the seminal case in the area. It didn't jump right to ambiguity because there's a difference in the jurisprudence, so we're done here. Wipe its hands and move on to the next case. No, they looked at the Minnesota case, the seminal case. There was the anti-concurrent causation language, which was also at issue in Murray. What did the court do about that? It looked to a state appellate court case from Georgia. It attached an appendix of 38 out-of-state cases addressing that issue in the process of sorting out what the law of West Virginia should be. It did not jump to some big disagreement amongst cases nationally and say, well, we're done here. Policyholder wins. It did what courts always do in these cases, is it looked to the jurisprudence that was available. It sorted it out. And when it found cases from outside West Virginia to be persuasive, it said, Murray said, those cases are persuasive, and they applied them. So you get to the direct physical loss issue, which I mentioned a moment ago. You had these rocks hitting these houses and inevitably going to hit them again. And the court held that it was this permanency, this inability to inhabit these homes that caused this to meet the requirements for those policies. And again, nothing like that is alleged here. Here, businesses were all allowed, even if they weren't essential, to access and be in their property. They could be there to take care of the books. They could be there to handle phone calls. They could be there to plan for the future. They could be there to plan for the imminent end of these restrictive orders. They just couldn't entertain customers in the space during that limited period of time. Not so for the homeowners in Murray. Fire department said you have to leave and you're gone forever. Very different circumstance. There are similar interpretive rules that have been applied by other United States courts of appeals. There's the Gilreath case from the 11th Circuit, the Mud Pie case from the 9th Circuit. Both of them involved so-called stay-at-home orders. They both involved application of the plain and ordinary meaning rule. They both found that there was no permanent dispossession of those spaces and found that there was lacking any allegation of direct physical loss or direct physical damage that would allow the cases to go forward. Mud Pie is interesting also because it addressed a California appellate case called Hughes. Hughes is a marquee case in the briefs for Uncork. That's right up there with Murray. But the Mud Pie tells us, and we know this to be the case from reading Hughes, that Hughes is not at all about whether there's direct physical loss or damage. Indeed, in Hughes, it's demonstrable that there clearly was direct physical loss or damage. A large part of the property slid into the ocean. The issue was that destabilized the dwelling, and then they were looking at whether the land underneath the dwelling should be considered a part of the dwelling. That was the legal issue in Hughes, Hughes doesn't speak to direct physical loss or damage, and it's inappropriate to see it as such. So quick note about Santos. Santos, as I said a moment ago, addresses Murray, and importantly in that context also addresses cases like Port Authority or Seaford or the First Presbyterian Church case, among many others that are cited and relied on by Uncorked here, and disposed of those cases on the basis that I described earlier. As I mentioned, I think the main divide in this case is between Cincinnati's assertion that things ought to be seen in context and that context matters, and that's one of the first principles of insurance coverage law in West Virginia, and efforts by Uncorked to get out from under context. One of those efforts has to do with looking at dictionary definitions. The good example of why that approach should not be followed. We are told by Uncorked that, well, in the definition of period of restoration, it says repair, rebuild, or replace. And repair has a bunch of dictionary definitions. And one of them suggests that repair is in the context of repairing a relationship. So a parent and a child repairing their relationship, or two old friends repairing their relationship. That's where context, including overall context, matters. This is a commercial property policy. It isn't about interpersonal relationships. The fact that there is a definition of repair that addresses the context of interpersonal relationships simply doesn't speak to what we're about here. So look at the definitions of repair and the common sense meaning of repair in the context of an insurance, property insurance claim. The ordinary fact situation would be a fire or a storm. So the place is destroyed by the fire or the storm. That's property coverage. What do they get? They get a new place or repairs to the place that they've got. They also get this added extra coverage, which is the business income coverage, which is tethered to direct physical loss or damage, just like the damage from the storm or the fire is tethered to direct physical loss or damage.
Help me understand, like, how would something like this apply? What if there were an executive order that said places like Uncorked could stay open, but first they have to fix their ventilation systems. And so they have to like knock out their ceiling and put in big fans. And now I'm out of my area of expertise, but you get the drift. There's going to be some major structural repairs required. Would that be covered?
No, and here's the reason. For one thing, even to the degree one might see that as direct physical loss or damage, there are exclusions in the policy that we don't need to reach here and that we have not raised.
So putting to one side the exclusions, would it otherwise fall within the definition in your view? No,
because that's a government order regulating or restricting their operations, just like an order, for instance, from the fire department that says your maximum occupancy now is 100, not 120. Or something in terms of sign regulations. No, your sign can no longer be 20 feet high. We need it to be down at 5 feet high. All those sorts of things cost money to address, but they are not examples of direct physical loss or damage to property, right? And importantly, they're not examples of a situation where the suspension of operations is caused by direct physical loss or damage to property. Actually, the hypothetical posits that you have a suspension of operations and then you get into the issue of doing something to the property to comply with the government order.
Well, they wouldn't be accidental either, right? Like if the government orders you to, building codes have changed, and so now you have to install more, fire exits or something. That's not an accidental physical loss or an accidental physical damage.
It is not.
That's talking about a different part of the definition, but it's on purpose, but it's required by the government.
Yeah, very much so. And one last thing, since we're dealing with a hypothetical, it is conceivable in such circumstances that there would be options available to the property owner other than undertaking the work that's being ordered by the governmental entity. Sure, there are situations that I've at least seen in my personal experience. My brother runs restaurants where they decide that things that they're ordered to do aren't worth it, so they change the business model or they go to a different jurisdiction.
I'm not sure how much your colleague is really pressing this argument, but there is this argument in at least been adopted by some district courts that fine, the suspension order is not a physical loss or damage, but the presence of the virus on the property is itself a form of physical damage. And then they cite cases about smoke and noxious gases and other airborne particles that have in some circumstances been deemed to constitute physical damage or physical loss. So is your position that that kind of airborne contaminant, because it doesn't sort of attach to physical property, can never be a physical loss or physical damage? Or is it that there's something different about COVID? How do you respond to that line of cases?
Well, yes, and there's more. First of all, when you look at those kinds of cases in the jurisprudence, asbestos I've already talked about, an odor case like Tritonich in Oregon that was a meth house, and cooking meth created permanent odors that could not be removed from the structure. You look at the First Presbyterian Church case from the Colorado Supreme Court, those were fumes from petroleum, but those fumes permeated the structure and could not be removed, at least not without steps or efforts that they were apparently unwilling to make. But the fact of the matter is that they permeated the structure in the first instance. Same with smoke. If anybody's ever been over to somebody's place where they've had a bad kitchen fire, one of the issues the homeowner might comment on is the place still smells like smoke. I can smell it. And that's an example of a situation where it can be permanently affecting and changing the physical property. That's not COVID. How do we know that's not COVID? Well, first and foremost, and the court, I believe, can take judicial notice of this. We argued and cited the support for this in the trial court, that the trial court could take judicial notice of the CDC's findings and directions. And what the Centers for Disease Control tell us is this can always be wiped up with a disinfectant or even soap and water. Okay, how's that different from other maintenance? My very first job in life, real job other than cutting grass, was to be a dishwasher in a steakhouse. And every night I had to mop the floor. Never for a minute occurred to me that I was repairing damage to the floor. It was maintenance. I was cleaning it, right? That's the COVID story. Very different from those other sorts of cases in terms of what I think this court can take judicial notice about, which is it can always be cleaned with soap or disinfectant. And that takes us into the Mama Joe's case from the 11th Circuit Court of Appeals, which dealt with dust and debris from road construction. And they wanted to be paid for cleaning that up periodically while the road construction was going on. And the 11th Circuit held in that case, applying Florida law, that no, that's maintenance. That's not direct physical loss or damage to property. It's something quite different again. And that case has been followed subsequently in the 11th Circuit as well as by federal district courts in that circuit. I note that my time is up, but if there's more that I can answer, happy to do that. All I would ask then is that the trial court's decision be affirmed and that we not accept an invitation to look at this situation as an opportunity to apply some linguistic alchemy to try to make these plain and unambiguous terms into something that they are not. Thank you.
Thank you. Mr. Martin, I think you have some rebuttal time. Yeah.
Okay. Thank you, Your Honors. In this effort to look at out-of-state authority, obviously that's a two-edged sword here because of the conflict in those decisions. But importantly, in looking at that out-of-state authority, you'll find in cases like Mud Pie or Santos, there is an underlying state court decision that gives rise to the court's coverage analysis, something that is here in Murray and here in Chafin, both cases which lead in a very different direction. As far as disdaining dictionary definitions or calling this alchemy, when terms are undefined in a policy, that's exactly what West Virginia courts do. As far as repair is concerned, for example, that can mean restore to use. That is the essence of what we are advocating here, because our property, as a result of the virus and the closure orders, was unusable. As to accidental, Your Honor, That can be looked at in this policy as coming from the perspective of the insured. And certainly there was nothing accidental about these closure orders from its perspective. So there is no compulsion to read the policy in the way that the insurers suggest. Quite the contrary, we should be looking for ways to read this in favor of coverage. Now that brings us back to Murray as the underlying case. All the facts of Murray were dumped in as though those were limiting principles that the Supreme Court of West Virginia applied in deciding the case. It didn't. Murray, we know, looked at the effect on the property. That's what Uncork urges here. The residence was unusable. That's what Uncork says here. The West Virginia court, when it said it directly, said that physical loss may exist in the absence of structural damage to the insured property, exactly what Uncork urges here, and does not include losses rendering the insured property unusable, exactly what Uncork urges here as a result of the closure orders. Now, Murray did talk about the property being damaged, but the court did not put that in terms of a limitation on coverage. And at the very minimum, Murray can be read to support the construction that we offered. So then the question is, would a West Virginia court narrow this down the way that they have suggested? And as I said, there isn't a reason to think that it would. There is nothing in this policy that requires physical or structural authorization written clearly and unmistakably.
Hey, Mr. Martin, what about the fact that we're not just talking under the policy language of direct physical loss, we're talking about direct physical loss to property?
That's correct, Your Honor.
And not a loss to the business and not a loss to the use of the premises,
Right.
but a loss to the property.
So two doesn't add anything except more ambiguity to what it might mean in context when all the terms are read. But the loss to the property here is the physical inability to use it. That's what happened to Uncork.
Seems to me then you're arguing that the loss to the policyholder equals the loss, in other words, the loss of access for business purposes equals a physical loss to the property.
A policyholder could say, I have this water here. The virus and closure orders take it away. That is physically lost to me for its intended purpose. I can't drink it. That is the construction that a West Virginia court would adopt. It would not go to revisions to this policy injected by the insurer to give it clarity that it doesn't have. It also would not follow the mode of analysis that the district court did, where the court disdained any real look at the definitions in ordinary parlance of these terms, jumped directly to the out-of-state cases to define tangible and structural as being required, which are not in the policy. Those are limitations injected in, and went on to find that construction. In addition, and lastly, I might add that as to the period of restoration and all of that, the same analysis follows. Certainly, you can read this policy the way that Cincinnati suggests, but that does not mean that you read it to exclude the events or conditions that we have offered, which fit within the policy's terms. Thank you.
Thank you very much. We thank both of you. We are sorry we cannot come down and shake hands and thank you in person. We very much appreciate you being with us today, and we hope we will see you again soon. And with that, court is adjourned for the day, and we will start again tomorrow.
Council, please. Oh, I see you both already done, so thank you.
Leasing my campsite.